This conference will now be recorded.
Greetings. I'm Minnie Bishop. I'm the statewide DRE coordinator, and I'm going to be co-facilitating with
Mark Rewald. I am the Director of Research for the Florida Department of Juvenile Justice, and today we're going to be talking to you about the new detention risk assessment instrument, as well as changes that are coming to home detention, what will now be called supervised release. And so today we're going to briefly review what the purpose of secure detention is, a history of the DRE, why it came about, where it came about, the reasoning behind it. We're going to lay out some of the challenges that we have with the existing DRE that's been in use in Florida since the mid-1990s. We're going to briefly cover the overview of the research that went into building the new detention risk assessment instrument. We're going to share what the predicted impact is going to be going from the old DRE to the new DRE. And then we're also going to spend time talking about changes to supervised release, which is coming along with the new detention risk assessment instrument. So what is the purpose of secure detention? And so there's really only three legitimate uses for secure detention in the state of Florida. The first is to incapacitate youth who are deemed to be a short-term threat to public safety, youth that are committing crimes at a high rate or are committing dangerous crimes. The purpose of the DRE is to help us figure out who should be in secure detention, who's a threat to public safety, or is a flight risk, kids who fail to appear for court, miss court hearings, things of that nature. The third, albeit less frequent option, is a youth can request to be detained to keep them from harming themselves or from being harmed by others. A recent example we had of that was a very young youth who was detained in the South Florida facility for his own protection because he was a witness against gang members and was being temporarily held in the secure detention facility for his own safety. So the DRE, where did it come from? And so Florida has had a DRE since 1994. We were the first state to have a detention risk assessment instrument. The DRE came about because of serious overcrowding in Florida. If you were to look at crime rates and arrests, crimes done to police back in the mid-90s, you would notice that in Florida and around the country, delinquency was at its peak. To give an example of what that means, last year the department processed roughly 60,000 delinquency arrests all throughout Florida. If you go back to the mid-1990s, we processed approximately 180,000 delinquency arrests throughout the state. And detention centers were, quite frankly, overflowing. We actually had some centers that were so overcrowded that juveniles slept in shifts because we just physically did not have enough room. Detention centers have what we like to call elastic walls. If we have a 50-bed facility, but there are 75 youth detained, we hold 75 youth, or 100 youth, or 125 youth. And when facilities are that overcrowded, it creates a lot of problems. But one of the things we noticed was that there was no real structured way to determine who is genuinely a threat to public safety and who's a flight risk. And so working with folks from the Annie E. Casey Foundation, the department developed the first juvenile detention risk assessment instrument in the United States, and that was developed in 1994. Florida is recognized as having one of the most advanced data and statistical analysis capabilities in the country, but back in the 90s, our capacities weren't anywhere near what they are today. And they built the instrument based on what they believed would be the best predictors for determining short-term threat to public safety and flight risk, but they didn't really have a lot of data and research to go on at that point. But it was the first risk assessment instrument in the United States. It has been shown to be valid. It is a valid predictor of risk. However, that's not terribly impressive because if you use nothing more than gender to determine whether or not somebody is a risk, you're automatically going to have a valid instrument because boys are substantially more likely to be rearrested or commit crimes than girls are. What we wanted to do is find out how can we improve the DRE. And we wanted to deal with some of the challenges that we had with the original detention risk assessment. There's quite a few of them. One of the biggest issues with the DRE is it's hands down, the existing DRE we have right now, the most complicated detention risk assessment instrument in the United States. It is exceptionally long. It has a lot of criteria you have to determine whether youth meet before you even score the youth. And it lends itself to a lot of errors. To try and address some of those errors, we tried automating as much of the tool as possible several years ago, but it's still an extremely complex instrument. One of the things we found in our validation work was that most of the admission criteria we go through using the current DRE have absolutely no relationship to risk whatsoever. They're not valuable at all. They were put in the instrument for good reason. They may sound well, but they just were found to not have any relationship to risk whatsoever. There's also the issue of double counting firearms, which we can go into in more detail if you have questions. But essentially, youth will get points for having an offense that has certain types of criteria involving a firearm, and then we add points on top of that. But in function, if you were found in possession of a firearm, we were putting you in detention, and we're letting the court sort that out the next day, regardless of what the tool says, because being in possession of a firearm is serious business in juvenile justice. But that creates a legal problem. One of the other issues that we had that made the research that we conducted very, very difficult was that most kids don't actually get scored. You might get screened, but you don't actually get scored. It may be that there's a court order to detain the youth, and so we just check that box and we don't actually do the scoring, or you don't meet certain criteria based on the admission criteria that are on the DRE. And so that makes the analysis somewhat difficult, although we were able to put in place a number of different things to analyze the effectiveness of the current DRE. But we found in 2014, where we first started looking at whether or not the DRE was predictive, we found that it was. But we also found that it was possible to simplify the instrument, improve the instrument, and make it more accurate at the same time. So does the current DRE work? The simplest answer is yes, it does. However, we can make it better. We can do a better job. And so that's what the new DRE is going to be doing. And so on our website, we have a webpage dedicated to the detention risk assessment instrument, the process. We have a number of different forms, descriptions, trainings. We also have the actual research that we put together as part of developing the new DRE. Today, we're going to give a very, very brief overview of the DRE and how it works. But we're not going to go into a lot of detail of all the different statistics and analyses that went into it. For that, I would refer you back to the report that we have on our website. It is a very, very comprehensive analysis. You will see that we went through just about every scenario you can imagine, analyzing things. This was the report that was used to inform the Detention Risk Assessment Committee that I'll be talking about shortly to help come up with the criteria that you're going to see on the actual DRE instrument itself. Now, the research team, what the department decided to do was to work with some external experts on this to help increase confidence in the tool that we came up with. And so we worked with Dr. Kristen Early from the Justice Research Center. She's a researcher with over 2 decades of experience working in juvenile justice and specifically with Florida's juvenile justice system. Dr. Kelly Dadel and Dr. Garth Davies are from out of state. However, they have worked on the review and validation of risk assessment instruments in jurisdictions throughout the United States. And so they had experience working specifically on this type of research that we wanted to bring into the equation. Then obviously the Office of Research and Data Integrity helps support the analysis by conducting analysis, preparing data sets, validations, things of that regard. But the goals for the research project were very, very simple. Our goal was to produce a detention risk assessment instrument that was predictive of risk and identify kids who are a threat to public safety or a threat to fail to appear. We wanted to make it more parsimonious, which means we wanted to make it less complicated. Could we make a form shorter, easier, less complex, but at the same time be more accurate than what we already have? We also wanted to make sure that we were not exacerbating issues related to gender, race, and ethnic disparities that we have in the juvenile justice system. Although that can be a topic for another day, there are racial and ethnic disparities throughout the juvenile justice system in Florida and around the country. And what we want to do is make sure that we're not exacerbating those by using tools like this to make sure that equally situated youth are treated equally by the instrument and by the system. And we also wanted to provide better guidance for enhanced community supervision options. Previously, today in Florida, home detention. Right now, there's 3 things are going to happen to you when you're arrested and you go through the intake process. Either you're going to be released on your own recognizance, you'll be released to some level of home detention, you'll have a home detention contract, or you'll go to secure detention. That's it. What we also wanted to do along with the DRE is come up with, a better tool, but also come up with better ways of working with kids that were going to be in the community to determine, what are kids that require limited contact and supervision to ensure compliance, and what are the kids who could safely be released to the community but would do better with enhanced contact and surveillance. And so those were the overall goals that we had for the project. The research strategy was fairly straightforward, and that one of the first things we had to do is we had to calculate DRE scores for a number of youth, because one of the problems we ran into was most of the kids that go through the process aren't actually scored. There might be a DRE, but we stop at the admission criteria, or we stop because there's a pickup order, a hold order, a warrant, or something like that. And so essentially what we did is we used all of that, and we were able to take quite a bit of data to look at kids who had already gone through the system. We were able to find youth who were detained and released, youth that weren't detained, kids that were detained and then let out very quickly, to use that to help build the models to determine what are the different criteria that are available to us, whether it was on the old DRE or not, that were the strongest predictors of short-term risk to reoffend and flight risk. And it's also very important to point out we're looking at the DRE as short-term risk to reoffend, which is different than long-term risk to reoffend. And so what is the likelihood a juvenile is going to engage in new delinquent behavior, for example, in the first 21 days, 30 days, 60 days? We looked at multiple time periods to make sure that we were really getting this right. And again, I would refer you back to the actual research report to go through all the different analyses that we presented along with this. But the DRE study and validation work was prepared and then presented to the committee. They call it the 2x2 committee. This is a group of individuals who are laid out and identified in statute. Statute dictates that the department cannot change this instrument without the advice and consent of persons that are on this committee. And it involves representation from Conference of Circuit Judges, prosecuting attorneys, public defenders, the Sheriff's Association, and the Association of Chiefs of Police. The department reached out to each of these respective associations and asked them to provide 2 representatives to be the members of this team that we could work with on designing and implementing a new detention risk assessment instrument. What you see on the screen right now is a list of the actual members who are on the DRE committee. We met with this committee 5 times. We had multiple phone calls as well to share the actual results of the research, to have some back and forth, get their feedback, to come up with a tool that we're going to be sharing with today. But these are the folks that were actually on the committee. They went through the analysis in detail, asked a number of different questions. They were able to provide very good guidance to the research team that we could take back and run a number of different models to show them, well, this is what happens if we do this. This is what happens if we do this. One of the things that I can tell you about the DRE is it is data-driven. It's not driven based on philosophy, gut feelings. It is based on what the data actually shows us. Who is a threat to public safety versus who isn't. Who can be released safely to the community with a low likelihood of reoffending versus who actually needs to go to secure detention versus who can just be released outright. And so the instrument itself, we're going to start going through the instrument and showing you what's going to be on the new DRE. A couple of points that I'm going to set up before Ms. Bishop starts to speak. It is very, very important that you understand the new detention risk assessment instrument is different from the old risk assessment instrument. The scoring that we're going to go through is completely different than the scoring in the old DRE. So, for example, in the old DRE, you needed 12 points to reach the threshold where you go to secure detention. A 12 on the old DRE has absolutely nothing to do with a 12 on the new DRE. So I don't want you being distracted by that as she goes through the different criteria. Another thing to keep in mind as you're going through this is that the items that are in here that we're showing you are what the data showed us was predictive of reoffending. We did not plug in things because it made us feel good. If it's on here, it's because the data showed that this is what we need to use to predict short-term risk to reoffend or failing to appear. Another thing to keep in mind is, although we're going to go through and show this to you in sections, you have to think about how all these different sections will work together. So just because someone may get points on this section, they may not be getting points in another section, or they may be getting points in all sections. So as we're going through it, think about how all these different sections are going to work together to come up with the combined score that we're going to use to determine whether you're going to be detained or not.
So after all the research and meetings, what does the instrument look like? The first point to understand is that the purpose of the DRE is to predict whether or not the child will commit a new crime or fail to appear within that short window of time. And although our statute only allows for 21 to 30 days of detention status, again, as Mark said, we use research a time frame up to 60 days just to make sure we were classifying the kids appropriately. And so as I go through this instrument, I'm going to do it from the screener's perspective or what they would see. So kids, of course, are presented for screening with an affidavit from an officer that has offenses on it. There might be one affidavit. There may be multiple affidavits. They're going to review those affidavits and analyze the presenting charges. They'll open up the instrument and they will begin with the first page, which includes the identification information, the charges, and some research on the kid's DCF history and conversations with the parent if the screener was able to have one. This page looks almost identical to the instrument that we use. It's just been updated tremendously. So, for example, in the top right corner of the instrument that we use today in April of 2019, it still requests an HRS number. And we, of course, know HRS was dissolved in the 90s. And so that has been taken off. The other things that are different about this page is that the paragraph related to underlying offenses is no longer there, and we'll talk about why that is in a little bit. And then the biggest upgrade is that the charges are at the bottom of the page. That's to allow all of the charges to be listed together. So whether there is one offense or 20 offenses, all of the presenting charges will be presented together. And if there's more presenting charges than lines available at the bottom of the page, then the presenting charges will become the second page of the instrument so that they're all grouped together. So the screener will go through and fill out all of the demographic information, who was the law enforcement agency, what is the arresting officer's name and badge number, verify that the youth's rights were reviewed and that we checked the BCF abuse history and what we found on that history. So to help judges make decisions about placement for kids that are going back out in the community. And then noting the kid's address and whether or not we talked to a parent during this screening. These are the five things that were the five categories that were determined to be predictive of that short-term risk of committing a new offense or failing to appear. So the most serious presenting offense, the number of prior referrals the youth has, delinquency history, their current legal status, and their current age. And we're going to talk about each of these in detail. So again, the screener takes the arrest affidavit or affidavits that have been presented today, and they look through the list of charges and compare them to the first section. As we go through each section, it has to be noted that there are some sections in which the youth can meet multiple of the factors listed. If that is the case, the screener is always going to choose the factor with the highest point value for that section. But we are only choosing 1 point value for each of the sections. So in analyzing the presenting offenses, the screener is going to start from the top of this page and work their way down to identify if one of those offenses meets one of the descriptions in this section. And when they find a description that matches any one of the charges that was presented today, that is the point value that the child is going to get for this section. So if there is a capital life, first degree punishable by life, or PBL offense, a violent second or first degree felony or vehicular homicide, or any offense involving the use or possession of a firearm, then that child is going to get 20 points in this section. So common questions about those first three, A, B, and C. One, how does the department determine violence? As a part of the DRE committee process, we actually had that discussion, and the DRE committee went through the department's violent offense list because, as you may or may not know, the term violence is not defined in statute. It is almost a matter of opinion. And so we wanted to make sure that the standard of violence that the Department of Juvenile Justice is using was in line with our sister criminal justice agencies. And so we compared our list to FDLE standard, to DOC standard, and we also looked at the forcible felony statute to make modifications. And the violent offense list that we began using in February of 2018 is the violent offense list that will continue to be used at the rollout of this new DRE that was approved by the DRE committee. And so we are now using the same standard of violence as all of the other criminal justice agencies in the state of Florida. The second most common question about A, B, and C is about C, any offense involving the use and possession of a firearm. It is literally any offense. So it can be a misdemeanor or a felony. It can be an offense in which the officer describes that there was use or possession of a firearm but didn't necessarily charge the youth with a firearm, but clearly tells us that the youth either used or possessed a firearm while committing that particular crime. So if any of those situations occur, again, that child is going to get 20 points in this particular section. D is violent third-degree felonies, burglary of a dwelling. Those statute numbers represent occupied and unoccupied. And then 5 or more burglary offenses at once. And this is literally any 5 burglary offenses, doesn't matter the type, doesn't matter if they were presented on one affidavit or multiple affidavits. It just matters that all 5 of them were presented at one time. The child would get 10 points in this section. E is for nonviolent offenses and misdemeanors. So any nonviolent felonies and any misdemeanor gets 6 if that is the most serious presenting offense. And then F is the new one, technical violations and or municipal ordinances. Municipal ordinances actually is a part of the Delinquent Act statute. It is in that definition, and so it should have always been a part of the instrument, so we are correcting that. And then technical violations is an addition because we get a number of technical violations, and if you take the time to review the analysis, you will see that kids presented for technical violations score across the entire spectrum. There are some that score for release, and there are some that score all the way up to secure detention, although most of them will fall into the middle category as they do today. So after the screener has reviewed all of the presenting offenses and identified the highest point value applicable to that child, they'll go to Section 2, which is prior referrals. And they will simply add up the number of prior referrals or arrests that child has had for an actual offense. So we're only counting misdemeanor and felony referrals. We are not counting any other type of referral. And all referrals will be counted up until they are thrown out of the court process in some shape, form, or fashion. So from intake all the way to being on probation, or if they successfully completed and it was just closed, it will be counted. It will no longer be counted at the point that it is non-filed, dismissed, or null pros. Another note is, although practices are varied throughout the state, we wanted to make sure that folks understood that pre-arrest programs, civil citation, or equivalent should not be counted. That is, should not be considered an arrest, and so it should not be counted in this section. We're only counting prior arrests for that child. So if there are 3 or more prior arrests, then the child gets 3 points. 2 would be 2 points. 1 prior arrest would be 0 points. And then if this is the child's first time ever being arrested and presented, we would actually subtract a point. And again, as Mark said, that goes back to making sure children fall into the right grouping to get the appropriate amount of supervision to ensure that they go to court and that they do not commit new offenses in the short time frame that detention provides supervision. Detention care is available, I should say. Delinquency history is the next section, and again, the pattern or the rule is the same. We will count these factors until they are dismissed, withdrawn, non-filed, or null pros at some point in the court process. And so if a youth has a prior escape or abscond, or if they are being presented today for an abscond, they're going to get 4 points in this section. Law violations prior to court hearing, again, the purpose of the instrument is to determine if the child is going to go commit a new offense while going through the court hearing process. And so it makes sense that that has a pretty high point value. The definition there is the same definition the department has used for about 10 years or so in determining what a law violation prior to court hearing looks like. 2 or more failure to appears. These are failure to appears that have actually been processed and screened. And we are going to focus on offense states to determine if the youth failed to appear 2 or more times. The reason that's important is because if the child has multiple cases going through the court process at the same time, oftentimes jurisdiction will hear all of the cases at once. And so if the child has 3 open cases, for example, and they fail to appear to 1 court hearing, there is a failure to appear order issued for each case. So on a face sheet or the criminal history, you may see 3 failure to appears listed, but the child actually only failed to appear once. And so it should be counted 1 time because that was 1 incident. And if the child has 2 or more incidents, then they will receive 3 points. The next one is history of violations. This is any kind of violation for any type of supervision. People typically focus on probation, but you can violate home detention. You can violate conditional release. So this is any type of violation for any type of supervision, again, will be counted until that child, it is thrown out in some way, shape, form, or fashion, regardless of who originated the violation. And then if the child doesn't meet any of those descriptions as listed above, then we will subtract a point. Legal status, we count the current legal status. That is the way the research was conducted. And so if the child is on commitment or conditional release, which is the commitment status, then they receive 4 points. If they were in detention or on a supervised release program, supervised release is a type of detention status that we're going to discuss in more detail a little bit later. they will receive 3 points. And then the 90-day mark that exists on the current instrument was a really good determinant, according to the research, and so it remains a part of this instrument. So probation or post-commitment probation, which is a probation status, for less than 90 days is 3 points. And if they have been on probation more than 90 days, then they get 2 points. And then again, if the child is not currently involved in any type of supervision as described above, we will subtract a point. The last section is the age at the time of the screening. So kids aged 12 and younger and 17 and older have the identical likelihood of failure. And again, by failure, I mean receiving a new charge or failing to appear in court as each other. So exact same likelihood of failure rate was applied or ended up being applicable to kids aged 12 and younger and kids aged 17 and older. But for those kids that are 13 to 16, the data showed that they were either 2 or 3 times more likely to commit an offense in that short amount of time. And so we allocate 1 point to account for that almost triple likelihood of failure in a short amount of time. And so after the screener has gone through those sections, we will add up the points. And if the child has 6 or fewer points, then they will be released on their own recognizance. If they score 7 to 12, then they fall in the middle category in supervised release. And we'll talk about more of what that looks like in a little bit. And then if they score 13 or more points, then they will be placed in secure detention. And again, a reminder of what Mr. Greenwald said earlier, these two instruments cannot be compared. The analysis that went into them and the way the points were allocated are completely different. It's like comparing apples and oranges. So a 12 on this instrument is not comparable to a 12 on the old instrument. And so having done a brief walkthrough of what the instrument looks like, Mr. Greenwald is going to talk about what the predictive impact of that instrument is.
So what does all this mean? So what's going to happen? And so what we're going to do is walk you through what the data shows when we look at youth who went through the system using the old DRE and applying the new DRE on top of those actual cases. And so this is a chart that shows you of those cases how the outcomes may have been the same or differed, be it up or down. And so the shaded brown cases in the middle are where things would stay the same. 60% of the cases would have gotten the exact same score that they received. And so, for example, 17% of youth screened using the current DRE would have gotten a release, and 17% of youth, this is the top left-hand corner, that would have received the new DRE would have been released. 10% for supervised release, and then 33% for detention. Now, the light shaded blue shows youth that would be getting a more restrictive setting under the proposed DRE. 50% of kids would actually be going up a level on the new DRE. And so, for example, in the current DRE, we have 26% of kids who went through ended up getting an outright release. Now, if you look at the proposed DRE, it's going to be 24%. But if we go to detention, you have 41% of youth who went through on the proposed DRE would actually be going to secure detention, whereas on the old DRE, 56% of kids who went through and got screened would end up going to detention. So you're going to see a reduction in the overall number of kids who go to secure detention. You're going to see a slight reduction in the number of kids who go to, slight increase in the number of kids who go to outright release. But you're going to see an increase mostly in kids that are going to the actual changes that we're going to be seeing in supervised release. These are kids that are going to be going into the community, which was old, what we referred to previously as home detention is now going to be changed into supervised release. These are what the results look like for male and female youth, just to show the general breakdown. Males are more likely to end up in secure detention. Males are more likely to be engaged in delinquency. They're more likely to be engaged in violent crimes, the kind of things that are going to score you points to get into secure detention. But looking at all the referrals that come into intake, roughly 3/4 of the youth that come in are male, 23% are female. 45% of males end up being detained, 21% receive an outright release, and 34% will go to supervised release. The DRE outcomes on the new DRE for females is a little more mixed in terms of a third, a third, a third. 37% of youth are going to go to supervised release, 27% are going to go to secure detention, and 36% are going to go to supervised release. One of the other things that we did as part of this study, and again, I'll refer you back to the analysis, is we did what are called race, gender, and ethnic neutrality checks to make sure that the tool is not introducing any new bias into the process, to make sure that equally situated youth are getting the same equally situated outcomes. Now, these are what the recidivism rates look like at 21 days using the current DRE compared to the proposed DRE. And I'm going to start with the release, which is on the left-hand side. So using the current DRE, youth who are scored and get an outright release, 9% of those youth are picking up some type of offense or violation within the first 21 days. Using the new DRE, that will drop to 6%. And so you will see an improvement. The kids that are going to outright release, there will be an improvement in the violation rates for those youth. For supervised release, we will see absolutely no change. If we did absolutely nothing in our system and just used the new DRE itself, you would see no change in the rate of failure for the kids that are going to supervised release today compared to the kids that were going to supervised release in the new DRE that's going to be released here in a couple of months. Now, what we believe, though, is because we are enhancing the supervision and surveillance of youth around supervised release, which Minnie's going to talk to you about in the next section, we actually believe those rates are going to come down. So we're actually going to see an improvement in the failure rates for kids that are going to supervised release. It's completely reasonable that as we implement these new standards for supervised release, these new contact standards, that violations may tick up slightly once we implement those, because kids will have to get the message that there will be enhanced supervision and surveillance. People will be knocking on doors more so than they are now. And so it may take a little bit of time for that message to get across. But what we have seen when we have done similar things throughout the system is that although sometimes there's a slight uptick when you start, it then flattens out and then declines. And so we believe the supervised release number, even though it won't change if we did nothing, will actually come down once we get these new changes into place. And that's what Minnie's going to talk to you about after we talk about how we're going to deal with statutory and policy overrides.
So having gone through the instrument, there are always going to be extenuating circumstances or situations that we need to be able to deal with that will still occur. And so if you were looking at the instrument, after you go through the scoring page, there's a section for statute and policy overrides, which is a list of scenarios we know we see often that the committee wanted to provide a remedy for. So the first one is youth wanted in another jurisdiction. These are kids that are wanted for felony offenses in other jurisdictions or wanted in other states. The instrument allows for the child to go to secure detention so that they can be transported to the area of jurisdiction, regardless of score. So example is if a kid is in Tallahassee and they're arrested for a felony warrant that is out of Miami, the only way we would be able to get that kid to the area that has jurisdiction over the case is through the detention transport system. And so the instrument allows for kids to be placed in secure detention for transport to the area that has jurisdiction over their pending case. The second one is youth who request to go to secure detention. We see this most often related to gang-related issues. So the youth is in fear for their own safety, and they will request to go to secure detention. Now, our screeners, of course, will try to find an alternative option that is viable that will keep the kids safe. But if that fails, the kid can actually be placed in secure detention at their own request. And Mark gave an example of that a little bit earlier. And this would happen regardless of score. Now, the screener would connect the child with an attorney so that they can talk through their rights and make sure that this is really what the child wants. And then the child will work with the attorney to put their request in writing. And then we use that written document as documentation, collateral documentation to submit to the judge as to why this child is being detained. The next scenario is domestic violence. Now, while we have come a long way as relates to how we deal with domestic violence cases, we will still have incidences where it is not safe for the youth to return home for protection of the victim, and there is no alternative setting that is available that would remedy the situation. And so being able to place kids in secure detention as a result of domestic violence has to, of course, be an option available. Again, we've come a long way. We went from a complete reliance on secure detention for these cases to entering into a contract with the network to provide shelter care and, more importantly, services to these youth and their families related to domestic violence situations. And as a result, our recidivism rates for domestic violence cases has dropped. And we are looking to improve that practice even more with the rollout of a DV typology that the network is going to be doing to make sure we're matching the right kinds of services to the right kinds of kids and families. The next situation is PJO, or a prolific juvenile offender. This phrase is defined in statute, and our community systems are programmed to determine if the youth meets the eligibility for this classification according to their history and what the statute dictates. And so if the child meets the criteria for PJO, they will go to secure detention for the initial night, regardless of score, for the court to determine what the best supervision option is for that child. The underlying charge considerations. So there was a lot of debate in the committee about underlying charges. And for those that are not familiar, an underlying charge is a charge for which a youth is currently under some type of DJJ supervision. And so the compromise was that if the child's underlying charge, if there's one that exists, and that underlying charge is an offense that would score 20 points, and that most serious presenting offense section of the instrument, then that child will be placed in secure detention for the court to make a determination of the supervision appropriate for that child the next day. So again, if the child's underlying offense is a capital life PVL, a violent first or second degree felony, vehicular homicide, or any offense involving the use or possession of a firearm, then they will be placed in secure detention for that night for the judge to make a determination. And the last one is, of course, judicial order. So if the department receives a court order dictating a specific outcome, then we are obligated to abide by the request of that court order, regardless of score. And so we will do so. We will be identifying the reasons for which the court order was issued, so we can identify patterns across the state. And the reason we want to do this is because as we talk to judges, they talk about not having enough options. And so we feel like if we can collect data about what the common issues are that may be making a judge feel like the child needs to be placed in secure detention, we might be able to find some more remedies that resolve the issue similar to the work we've done around DV that are not reliant on secure detention. Again, or we may not be, but we'd like to understand the patterns and be able to show the judges the patterns in their circuits, which they seem to appreciate. It's important for me to note that this statutory policy override section does not modify the score in any way. The score is what the score is. These overrides are placement overrides. But whatever the end result score was on that second page of the instrument will remain what is presented in court, and then we will mark whether or not one of these overrides is applicable and modify the placement accordingly. The last thing you see listed on this PowerPoint is the state attorney review consultation. So it's important for me to say that the decisions made in screening around the state have to be consistent, they have to be objective, and it had to be based on information that was available to the screener 24 hours a day, 7 days a week, whether I'm in Pensacola or Miami. So all of the things that you see on the scoring page are all things that can be identified pretty much in black and white. But there are instances where screeners will have additional information that may lead them to feel that the outcome of the instrument needs to be modified in some shape, form, or fashion. And so historically, the screeners have been allowed to aggravate or mitigate the score up to 3 points in either section to modify the placement one level up or down based on a set of pre-approved factors or options that they had. In speaking to our national experts, when individuals are given discretion as it relates to instruments like this, typically they will not use them. And then if they do use them, then the way in which they use them is oftentimes highly inappropriate. Sad to say, our research in Florida fit that model. The aggravating and or mitigating factors were used in, I want to say, less than 1% of the cases, although a lot more of them had aggravating and or mitigating factors that would have been applicable to their case. So it wasn't being done consistently. And then of that less than 1%, of course, we tended to aggravate more than mitigate, and the reasons actually were highly inappropriate and didn't match the pre-approved factors. And so the screener's ability to aggravate and or mitigate is being removed, but they will have the ability to contact the state attorney to review the objective factual information that they have before them to make a determination if the placement needs to be modified one category. The state attorney review decision has always been a part of this instrument. It's just becoming a little bit more important with the way the new instrument works. So common questions about this is, what's an example of an aggravating or mitigating factor that a screener might reach out to a state attorney to talk about? A simple aggravating factor example that I know everyone will understand is right after the Marjory Stoneman Douglas incident, we had a number of threats to kills in school where screeners had actual Facebook posts or Snapchats or Instagram posts of kids with guns making threats. That particular charge, though, was not on our violent offense list that they had. And so the kids were scoring for a release option when it was very evident that the kid had the ability to actually act on the threat. So screeners would be able to use the information that they have that is clearly objective, contact the state attorney, and modify that placement accordingly. Now, the issue with the threat to kill charges, I should say, has been resolved. It is actually, that charge was actually on the violent offense list that was approved by the DRE committee, but that approval had just happened and we had not gotten the new list out. And so this would have been a Band-Aid until we updated our systems, which we fixed very quickly. An example of a mitigating factor is a kid that, of course, is known to us, and we know that the behavior is a direct result of mental health issues that child has. We, of course, with our information that we are aware of or have in our system, could contact the state attorney, speak to them about that, and get them to agree that maybe we modify the placement a little bit. So that's an example of a mitigating factor. So we want whatever the factors or the information that's used to modify the placement to be something that is objective, and we want them to consult with an outside third party to get agreement with that. The state attorney that they speak to, of course, is noted on the instrument, and the details of the conversation is noted on the instrument and why the placement was changed. So a summary of our overall improvements. We wanted the DRE items to be reduced. We wanted it to be easier. We wanted it to be more predictive. We wanted it to be even more automated than it is now, to prevent as much human error as we possibly can. We wanted it to be race, gender, ethnically neutral. And we wanted to avoid the cost and secure detention for kids that can actually be safely supervised in the community, and prevent it from committing a new crime or failing to appear in that short window of time. And then the last thing we wanted to do was expand the options of supervision in the middle category, because right now those options are one size fits all. Whether you score at the bottom of the middle category or at the top of the middle category, you get the same supervision level, and our research tells us that we should be matching our level of supervision or responses to the level of risk that the youth presents. And so we're going to try to correct that with supervised release. Mark, do you have any other sort of notes about improvements?
Yeah, the other thing that I wanted to mention was that we strongly encourage you to go to the department's website, because we are going to have a number of different reports that are going to be available to allow you to monitor the implementation of the DRE, how it is working, how the effectiveness of the alternatives that Minnie is about to talk about are going to work. And I will show you a little bit more about that towards the end of the PowerPoint.
So we've talked a lot. We've mentioned this term supervised release quite a bit. What is that? So a little bit of history, right? So the supervision statuses are the two types of detention that was listed in statute in the 90s and early 2000s, were secure and home detention, right? So home detention equates to one contact of supervision each week for the child. In about 2014, those statutes were modified. So the middle category that you will find in statute in April of 2019, the two options are actually secure and non-secure detention. And if you were to look at the definition of non-secure detention, it is actually a collection of different types of supervision. And so effective July 1, 2019, that non-secure detention statute is simply being renamed supervised release. So we can collect connect a range of supervision options for youth that fall into the middle category to the instrument. So all of these things are actually authorized by statute today, but because they're not linked to the instrument, the kids are not able to take advantage of them in the way the processes are working. So we're going to correct that. So again, supervised release is just an umbrella of supervision types, but the legal status itself is supervised release. And so what we've done, because the committee asked us to do some predictive, comparisons about what we predict versus what actually happens and the outcomes. So in order to do that in the best form, we've identified some target populations according to SCORE for each supervision level. And the supervision levels basically increase as you go up. They're listed from least intrusive to most intrusive. So again, home detention is 1 contact a week for kids. Intensive home detention, skipping to the third column, is multiple contacts a week. Right now the standard is 5, but we're still sort of making a final determination about that. And then intensive home detention with EM is exactly that. It's intensive home detention, but the kid has an electronic monitor on their leg as well. And we feel like the contacts are still very important for those kids that end up on EM, because our research has shown that EM itself does not deter delinquent behavior. It is the contact with the human being that actually makes an impact on whether or not the child will commit a new offense. So we wanted to make sure the contacts were still in place even for our highest risk kids. So home detention, intensive home detention, and intensive home detention with electronic monitoring will be available in all circuits across the state July 1. Some circuits actually have an evening reporting center as well. Palm Beach, which is Circuit 15, Circuit 6, which is in Pinellas County, Circuit 4 in Duval County, they already have evening reporting centers, and they've actually been piloting this project for a couple of years now. The evening reporting centers, this is a community center that has a structured schedule of programming that includes homework assistance, vocational schools, tutoring, family engagement, courses for kids. And the children are picked up from school, taken to the center. They stay at the center from 3 to 7 or 8. The hours vary depending on where you are. And then they are transported home when the center closes. And they are, of course, provided dinner at the center. What we have found is that kids make positive connections through mentoring and engaging in activities that they might not have been exposed to. They, of course, stay out of trouble. And in some of the places, they actually volunteer to keep coming back to the center even after their required time there has expired. So ERC's unique groups of kids, and so we have a list of circuits we feel like have the numbers to support this. We started again with those 3 or 4 circuits, and we're going to work over time to expand the availability of these across the state. So what you're looking at on the screen is a continuum of care. This is sort of a state level view. Again, this is draft, but every circuit will have a version of this that shows what's available as supervision options in their circuit. And some circuits will have programs that are just specific to their circuits, that are local circuits that meet our description of what supervised release programs should look like, that we have conversations with the circuits about, and we will incorporate them into their continuum. They just have to be willing to have that program be available and allow us to have a placement for it in JJS, make sure it meets our criteria for what we feel would fall in supervised release, so that we can report outcomes on local programs as well as the state-run programs. And then the last goal of this project is to make things transparent. This idea of screening and detention hearings and what happens to kids, I have been the department's DRE expert for more than 10 years, and I cannot tell you exactly what happens in that process. It's really a black box, and so we want to make it transparent. We want to know what's going on, and we want to report it so that we can get better over time, and that it won't be another 25 years before we improve this process based on what's happening with our kids to bring those recidivism rates even lower. And so we're going to be producing a number of reports that will be produced at least annually. So what were the instrument outcomes? How were they modified at detention hearings? What were the common reasons for that? How many times was the state attorney review decision used? What were the patterns for reasons for that? And then how are the supervised release programs going? What kids are placed on? and what are the outcomes of those programs. So it will be a very comprehensive report where circuits can kind of compare how they're doing to other circuits, make suggestions to us on how we can improve the process, and we can continue to grow as a state together.
So that's it, and I encourage you to go to the department's website. We anticipate having these reports ready in about 4 to 6 months after the DRE goes live. We just need time for data to get entered into our system so we can build reports around those reports, or build reports around that data. But I encourage you to go to our website. There's a tab at the top called Research. If you hover over it, we have lots of interactive data available to you, and that is where you will find those things. Thank you.
Thank you so much for your time, and have a great day.